Lecture 1. Contract Formation in the Internet Age. Professors often introduce first-year students to the law by describing it as a seamless web. This expression captures the fact that legal rules are surprisingly intertwined. Perhaps no area of the law exemplifies this phenomenon more than contracts. With the advent of the other seamless web in our lives, the internet, people enter into multiple contracts every day with the click of a button or a tap on a screen. By doing so, they often surrender rights from other threads of law such as torts, property, and civil procedure, and give up the power to recover for injuries or damaged property, or even the ability to go to court in the first place. With that background, this lecture explores how agreements have evolved over time. Consumers spend more than $450 billion through internet retailers every year, yet studies show that only about 0.1% of them actually scroll through contractual pop-up boxes. The objective theory of contracts. The first principle in contract law is that contracts arise from a mutual manifestation of assent. That word manifestation is crucial. It means that courts do not plumb the depths of the parties' psyches to ask whether they actually agreed to a deal. Instead, courts focus on whether the parties acted as though they agreed. This is known as the objective theory of contracts. A classic case from 1954 called Lucy v. Zemmer shows how easily a contract dispute can arise, and it also illustrates the objective theory of contracts in action. Zemmer owned a piece of land called the Ferguson Farm. Lucy had previously tried to buy it from Zemmer. One night just before Christmas, Lucy and Zemmer were drinking whiskey at a table in a restaurant. They started discussing the Ferguson Farm again. Eventually, Zemmer wrote on a piece of scratch paper that he agreed to sell the farm to Lucy for $50,000. Lucy suggested some minor changes to the language, and Zemmer tore up the paper, rewrote it, and signed his name. Later, Zemmer refused to sell the farm to Lucy, arguing that he had thought the whole exchange was a joke. The Virginia Supreme Court held that Zemmer's private belief was irrelevant. The important thing was that Zemmer had acted as though he was serious by creating multiple drafts of the writing, signing it, and talking about the transaction for a long time. No matter whether Zemmer subjectively agreed, he had manifested assent, and that was enough to create a binding contract for the farm. The purposes of the objective theory. The objective theory of contracts serves several purposes. It allows parties to rely on each other. It also makes life easier for the legal system. It is difficult for courts or juries to assess a party's mental state at a given point in time. In addition, a legal standard that is subjective would require a plaintiff or defendant to take the witness stand and talk about his or her thoughts and impressions. That would be tremendously time-consuming. Additionally, fact-finders might believe it to be fabricated, self-ing testimony. By ignoring this evidence, and focusing instead on the parties' conduct, the law takes a kind of shortcut, allowing the parties' words and actions to be proxy for his or her thoughts. The fine print. Like many venerable doctrines, the objective theory of contracts is based on the norms and assumptions of a different era. 500 years ago, contracts were often negotiated, face-to-face, between merchants or other parties who stood on relatively equal economic footing. Gradually, industrialization and new methods of communication altered the way contracts were consummated. In the early 20th century, different kind of contract emerged, the pre-printed standardized form. These contracts are not the product of bargaining. Instead, they are written by one party and offered to the other party on a take-it-or-leave basis. They are known as contracts of adhesion because the non-drafting parties adhere to the drafter's terms. They are also known as boilerplate contracts. Adhesion contracts have tremendous social value. After all, if companies had to negotiate with every customer over every aspect of every deal, the wheels of commerce would grind to a halt. However, adhesion contracts also have a troubling dimension. Toward the middle of the 20th century, businesses recognized that they could use fine print to alter the legal landscape around them. For example, car makers used fine print to disclaim their responsibility for manufacturing defects. Because fine print was such a potent weapon, adhesion contracts soon constituted an estimated 99% of all contracts. Bank loans sometimes define a year for the purposes of calculating interest rates as 360 days. This subtle change permits them to reap millions of dollars more in annual interest payments. This template of field contracts. Do they seem here? First, people agree to adhesion contracts blindly, almost nobody moves and text. Second, under traditional contract law, this is irrelevant. Under the objective theory of contracts, the key is whether a person manifests assent to a transaction. It does not matter whether they scrutinize every word in a document or more completely. Instead, they word things that he has clearly violated the dotted line. In fact, courts routinely enforce contracts even if the person who signed is illiterate or did not speak the language in which the document was written. Changing times. Some courts saw the need for change. Rather than saying that adhesion contracts lack movement and are not contracts at all, courts began to strike down unfair adhesive terms through a doctrine known as unconscionability, that is, the idea that a contract might be too harsh to force. Procedural unconscionability applies to adhesive terms that are difficult to see or understand. Substantive unconscionability is present in a particular term is incredibly unfair. If a provision is both procedurally and substantively unconscionable, it is invalid, although the rest of the contract continues to stand. In 1965, the United States Court of Appeals for the District of Columbia decided a case called Williams v. Walker on the furniture company that held unconscionability gained mainstream acceptance. However, in the 1970s, the pendulum swung in the other direction. One of the hallmarks of this era was the emergence of unreasonable opinions and articles. Judges and scholars who were versed in law and economics challenged the idea that there is such a thing as a harsh contract term. They argued that companies who something also lowers the company's cost of doing business. In competitive markets, anything that reduces a firm's bottom line also drives down prices. As a result, to say that a term is unfair only captures one side of the equation. These arguments found a receptive ear in the U.S. Supreme Court. By the middle of the 1970s, concern was mounting that the country was experiencing a litigation explosion. Some members of the Supreme Court began to see fine print as a way to alleviate the pressure on the judiciary. Citing law and economics view of adhesion contracts, they validated fine print that attempted to discourage claims or funnel claims outside of the court system. For example, in a 1991 decision called Carnival Cruise Lines, Inc. v. Shute, the court enforced a clause printed in microscopic font on the back of a ship ticket that required residents of Washington state to travel all the way to Florida to pursue a personal injury lawsuit against the cruise company. Electronic contracts. This adherence to contracts was the backdrop in the late 1990s and early 2000s, when the internet started to become the juggernaut it is today. Web-based businesses had seen the value to their brick-and-mortar counterparts of binding their patrons to adhesive clauses. However, at first, it was not clear how tech companies could replicate this model in cyberspace. In June 2000, Congress solved part of this problem by passing a statute known as the Electronic Signatures in Global and National Commerce Act, or the e-Sign Act. This law requires courts to treat electronic signatures precisely the same way they treat paper signatures. In addition, it defines the term electronic signature broadly, as an electronic sound, symbol, or process, executed or adopted by a person with the intent to sign the record. This means that typing OK or even X in an email can, in the right circumstances, count as a full-fledged signature. Controversial methods. Companies began to invent novel methods of getting consumers to accept terms online. The most controversial such method is known as browse wrap. Browse wraps lurk in inconspicuous places on websites. They are usually accessible through a hyperlink near the bottom of the first screen you visit on any particular site. Browse wraps say that you consent to their terms by using the site. Another common species of online agreement is the click wrap. Click wraps are ubiquitous boxes of text that pop up and force the user to click I agree. There are several species of click wrap. One is the scroll wrap. A scroll wrap is a pop-up box full of text that actually forces the user to scroll through the terms before the user can click I agree. Because scroll wraps place the contract terms front and center and then require the user to signal his or her acceptance of the terms, courts have unanimously found that users manifest assent to scroll wraps by clicking I agree. A slightly more fraught form of click wrap is the modified click wrap. Unlike scroll wraps, modified click wraps do not show the user a pop-up box full of terms. Instead, the website makes the terms accessible through a hyperlink near the I agree button. Cases featuring modified click wraps have involved the Hotwire travel website and video game companies and GA. Most courts have held that clicking an I agree button after being presented with a modified click wrap is a manifestation of assent. However, In a 2014 decision involving Barnes and Noble, the Ninth Circuit disagreed. A third and final kind of click wrap is the sign-in wrap contract. Sign-in wrap contracts might be formed when registering with a website, rather than when ordering a product, as with modified click wraps. There have been several high-profile opinions involving sign-in wrap contracts. One involved GoGo, the company that allows people to connect to Wi-Fi on airplanes. The other involved popular ride-sharing service Uber. Two federal judges in New York held that these firms' sign-in wrap terms were not binding. These courts explained that the sign-in wrap measures usually do not let users see the contract until they have nearly finished the process of registration.